Hi everyone. So today in this session, we are going to quickly complete the last area of compromise arrangements and amalgamation inside a concept called as LLP. So before we proceed into the concept of compromise arrangements and amalgamation, let me first explain you what is the meaning of this compromise and arrangement. Listen, whenever a LLP is not in a position to repay its debts, whenever a LLP is not in a position to repay its debts, in such a case, when the LLP is not in a position to repay the debts, it has to go for a compromise. It has to go for a compromise. The word compromise itself means there is a conflict. Okay? Resolving the conflict results in a compromise. Here, conflict means what conflict? Physically, two people are fighting. No. In the context of legal sense, the term conflict here represents a financial conflict. There is an LLP. That LLP has taken loan from the banks. That LLP has trade creditors, which it has to pay, but it could not pay to them properly. Now there is a conflict, financial conflict going on between LLP and the creditors, or sometimes partners may be there. Who may be there? Partners. As per the partnership agreement, LLP agreement, they have to comply with certain terms and conditions. But LLP is in a bad position. It is in a distressed position. In such case, LLP may not be able to, okay, pay all the liabilities like before. Therefore, to the partners also they wanted to go for a compromise. Representing what? See here. LLP will request the partners, actually our profit sharing ratio will be 1:1:1. Let us reduce it to 0.8 is to 0.8 is to 0.8, such that the balance can be transferred to the reserves. Future can be good in for this LLP. So please compromise 20% of your 80% share. Are you understanding or not? That means if each person has to get 1:1:1, okay, uh, whenever each person has to get 1:1:1, and if you could not pay them 1:1:1 profit, you wanted them to go for a compromise, then also the same section will get attracted. The main motive of this particular concept is whenever partners could not get their rights properly in the LLP, or whenever LLP could not pay the creditors as per the agreed terms and conditions, then they will be going for a compromise. I think I'm clear up to here now. Sir, I have one small, small surgery underwent here. That's why my voice may not be purely audible like before. Max 2-3 days it will get set right. So please pardon me for that. Conceptually, I will be managing each and every concept, but when it comes to talking, it will be very difficult for me. So therefore, my voice may be unclear. Please pardon me for that. Let's continue. So the point is, whenever there is a compromise, there is a dispute before. Dispute between whom and whom? Dispute between LLP and the partners. Dispute between LLP and the creditors. Okay. Whenever there is a dispute, we will go for a compromise for the dispute. Okay. Who will go for a compromise? LLP with their partners, LLP with their creditors will go for a compromise. Okay. But the problem is, if compromise is allowed, then every LLP, though their financial position is good, they will ask for that. Therefore, law said that compromise is not a final avenue available for everyone. You can't directly go for a compromise or arrangement. First, you need to make an application to tribunal. Everyone repeat. First, we need to make an application to the tribunal. Okay. Tribunal asking that tribunal, me, okay, me means the LLP is asking a compromise between me and creditors, or me with my partners. I want a compromise. Like that, we will first make an application to tribunal. What tribunal will do? Tribunal will not say yes and no. Do you know why? Tribunal is an outsider. Contract act, there is one concept called as a privity of contract. A third party don't get a better rights in a contract. Who the hell the tribunal is? Tribunal is a court. Court should do the judgment work. It should not involve in my LLP's internal works. So therefore, what maximum tribunal will do? Tribunal will tell that LLP, you go for compromise, but don't do as per your wish. I will tell how to do the compromise. You go according to the instructions of the tribunal. Tribunal means the NCLT court. Okay. Tribunal will give instructions about how to call, how to hold, how to conduct the meetings of creditors, meetings of members, meetings of creditors and meetings of members. So repeat. Point number 1. Who is going for a compromise? Compromise is proposed between LLP and creditors, LLP and the partners. Directly can they do? No. They have to apply to the tribunal. Application by the LLP to the tribunal. Okay. Next, on the application of LLP, who can make application? LLP can make application, or any creditor they themselves can make an application to tribunal, or partners can make an application, or if the LLP is in dissolution process, liquidator also can apply. So 4 persons can make an application to tribunal. Number 1, LLP can make, means designated partners will make, creditors can make, creditors can make, partners can make, liquidator in the case of winding up of LLP can make. Application to whom? Application to NCLT. For what? To sanction. To sanction what? Compromise or arrangement. Between whom and whom? LLP creditor, LLP partner. This is a paragraph number 1. What tribunal will do? It will say yes and no, na? No. Who the hell I am to tell yes or no for this compromise? Your creditors has to tell, your partners has to tell. Therefore, tribunal will give instructions as to how to call, hold and conduct the meetings between creditors and members. Meeting of creditors, meeting of partners. Number 1. Meeting started. How many creditors and how many members has to say okay? See here, there is one very important point. Majority representing 3/4 in the value of creditors or partners. What do you mean by that? If there are 100 partners who brought 1 crore capital, okay, 100 partners who is holding 1 crore capital. Now the question arises, majority representing 3/4 means first in this 51 should say yes. Majority means more than 50. Okay, 50% means how much? 50. More than 50 means 51 will be the more than 50. So 51 members should first say yes. That 51 members or more than 51 anything should hold 3/4 in value of this 1 crore. Means what? 83 members said yes. 83 partners said yes. Satisfied? No. That 83 should hold 75% of this particular 1 crore. Yes, approval is given. Creditors also same. Majority representing 3/4 in the value of creditors. They should say yes at the meeting. They should agree to the compromise or arrangement. Okay, agree to the compromise or arrangement. And you send the results of that agreed resolution to the tribunal. If tribunal is satisfied, then it will sanction. Once sanctioned, even though 83 plus 17 didn't say yes, it will be binding also on them. That's why order be binding on all the creditors, all the partners. It includes even those who said yes or no. Okay. Anyway, if they say yes, well and good. 83 only said yes, 17 didn't say yes, but 83 said yes. They are holding more than 75% of capital or not. That's all. It will apply on all others as well. Simply to tell, elections conducted, 2 persons standing for election. I voted for A, you voted for B. B win the elections. He became CM. He is a CM for you, for me, for everyone. Everyone. Even though I said no for that, he is a CM because majority approved them. Same. Next. Who will apply to the tribunal? LLP can apply. Partners can apply. Creditors can apply. Liquidator can apply. They will apply. Along with the application form, you need to attach one affidavit. Affidavit means a declaration of facts. What declaration we need to give? You need to give a declaration that no order will be given by the tribunal unless tribunal is satisfied that LLP or any other person by whom application has been made, remaining 3 people, has disclosed to the tribunal by an affidavit. Two things they need to mention. Okay. All material facts relating to LLP. Financial position. You should prove that your financial position is bad. Then only you will go for compromise. Number 3. If there is any pending investigation cases against your LLP, tell those. If those are there, tribunal will take reasonable care before giving you a compromise. Okay, over. Next, tribunal said yes. Order of tribunal should be filed with the registrar within 30 days. Within 30 days. That's all. Okay. So, next one. If there is any problem with this, this is only a penalty. This is only for remembrance sake. You remember that. There is nothing to discuss in this particular class. Okay. So, the main point that you need to understand is, first one, up to here is relevant for your exams here. Okay. So, main point. Compromise is entered between LLP and partner, LLP and creditor. Make an application to tribunal. Tribunal will give the instructions as to how to hold, call and conduct the meetings of the creditors and partners. Okay. Okay. Who can make application? LLP or creditor or partner or liquidator if the LLP is in winding up process. Over. How many should approve? Majority holding 3/4 in value should approve. Once approved, it will be binding on all the creditors and partners of this particular LLP. Number 2 also completed. Next, along with application form, you need to attach an affidavit, or else tribunal will not sanction the scheme. In that affidavit, you need to give 3 details. All material facts of that LLP. Okay. Next one, latest financial position showing that it is bad. And last but not the least, if there is any pending investigation proceedings, you need to tell that. Over. Order of tribunal should be filed with the ROC within 30 days, or else there will be a penalty. That's all. Now, who make an application? 4 people. Made an application to whom? Tribunal. Tribunal asks you to conduct what? Meeting. Meeting of whom? Creditors and partners. Conducted. Approved. Tribunal sanctioned the scheme. Now the work will start. Sanction order came. Now you have to apply that sanction order. You said, for example, in this particular section, what we will do? A question will arise. Okay. Under this section, what we will tell to the creditors, LLP has to pay you 1 crore. But our financial position is very bad. Now what we can do? We can sell the assets and pay you. But the assets also don't have a proper market value. So you will not receive good amount. You do one thing. Let's go for a compromise. 1 crore we have to pay you now. 20% you compromise. 80 lakhs we will pay on spot. Rather than selling the assets, waiting for the sale, waiting for the amount to come. After that, payment to all, in that scheme, I also should get a proper payment. It takes time and risk also. Rather than doing that, creditors will tell that, okay, I will go for compromise. If not, you can't pay 1 crore. At least pay immediately 80 lakhs. Taking 80 lakhs is better than not taking even 80 lakhs when you sell the assets. Therefore, they will go for compromise. Who accepted compromise? Creditors. Who accepted compromise? Partners. Later, who accepted it? Tribunal. Tribunal said that, okay, go as per the said scheme. What is the guarantee that after tribunal sanctioning you will do the same as per instructed by the tribunal? There is no guarantee. Therefore, tribunal will not just stop by giving sanction order. It will supervise the implementation of this process. That's what he wanted to tell. While tribunal makes an order, okay, in respect of that LLP, it has a power to supervise the scheme of compromise or arrangement. If at all you are not going as per the scheme, whatever sanctioned by the tribunal, tribunal will also have a right to make modifications to the compromise or arrangement for proper working of the compromise. Are you understand the point or not? Next stage, let's see the screen properly. If the tribunal is satisfied that compromise or arrangement sanctioned under section 60 cannot be worked satisfactorily, that means even after making modifications, you are not applying the scheme properly, you are trying to cheat the creditors and partners in the name of compromise, then what it can do? It can go for winding up of LLP. That means if the tribunal sanction order is not followed properly, tribunal can take a harsh decision like winding up of LLP as well. Okay. Next. This is the last section for this. What is the section? Amalgamation of LLP. What is this? Amalgamation of LLP. First, let me tell you certain things. Reconstruction is of two types. Internal reconstruction, external reconstruction. What do you mean by internal reconstruction? Just now we saw a creditors concept, partners, those are called as internal reconstruction. If one LLP with another LLP it goes for a merger or amalgamation, we call it as an external reconstruction. In the internal reconstruction, transfer of assets, transfer of liabilities, etc. will not be there. Compromises will be there. Waivers will be there. Waiver means 100 I will pay 80%, 20% waiver. Waivers will be there in case of compromise. But in case of a reconstruction being external reconstruction, there will be transfer of assets, transfer of liabilities. Okay, from one LLP to another LLP. One is a transferor LLP, another one is a transferee LLP. Okay, see here. Where an application is made to the tribunal under section 60. What do you mean by that? Same application, NCLT one form is there. Same NCLT one form will apply for 60 and also for 62. Same application form you take. There you will tick on compromise. Now here you tick on amalgamation. Okay, sanctioning compromise proposed between LLP and such other person mentioned in that section. Compromise or arrangement is proposed also in this section, but this compromise is in the nature of what? Reconstruction of any LLP or LLPs in the form of amalgamation. Means we are going for a total scheme of compromise or arrangement, but this compromise or arrangement application is made in the process of compromise, in the process of amalgamation. Section number 60 is a compromise, section number 62 is a amalgamation. Both are reconstructions. Okay, both are reconstruction. That is internal, this is external. Number one. So, point number one. Take the same application from what you used for section 60. There you made for compromise. Here you will make for compromise or arrangement. Name is compromise or arrangement. But nature of compromise or arrangement entered is not in the nature of a compromise, but in the nature of amalgamation. Next. Sir, what is the difference between the first compromise section and this one? There, waiver will be there. Okay, they will ask for a compromise. Here, whole or part of undertaking property or liabilities of one company called as a transfer or LLP is to be transferred to another company called as transferee LLP. Okay, when they transfer, what will be transferred? All the whole or part of the undertaking will be transferred. Number two, any legal proceedings pending in the name of transfer or LLP will transfer to the transferee LLP. That's called as a continuation of legal proceedings. Next one, we are not going to wind up. For example, LLP X is taken by LLP Y. What will happen? All the assets of X becomes assets of Y. All the liabilities of X becomes liabilities of Y. That means this old company called as X will lose its identity. It will be dissolved but not wound up. That's why the dissolution without winding up. Dissolution without winding up. Next one. Same concept. You are applying under section 60. Majority of creditors, majority of members, partners holding 3/4. Every approval is required like that only. Okay. Those who said no for that. For example, in our example, 83 or 17 said no. In this case, those 18 or those 83 balance 17 are there. Those 17 we call as a dissenting. We call them dissenting. Dissenting partners and creditors. Okay. If the dissenting creditors and partners are there who are not liking this scheme of amalgamation with another LLP, give them exit offer. Give them exit offer means pay them money, ask them to leave the firm. That's called as a provision to be made. Such other incidental matters, if any. Okay. That's the main concept that you need to understand in this area. So point number one. What is expected in the exam? They may ask a question to you. Explain the provisions of reconstruction of LLP. What you need to write? First one. Application should be made same as per section number 60. Under section number 60, what application you file? Same application you file. To whom you will file? Tribunal. By how many people they can file? 4. Same concept. How much approval is required? Majority holding 3/4. Same approval is required. But there, it is in the nature of a general compromise. This is a compromise or arrangement during the course of reconstruction. being a amalgamation. How can I know that this is amalgamation? There will be transfer of assets, liabilities, properties and obligations. Okay, tribunal will order. Then what will happen? Five things will happen. Transfer of assets, liabilities and properties from transferor LLP to transferee LLP. Legal proceedings will be continued in the name of transferee LLP. Dissolution of transferor company without winding up. Dissenting shareholders of transferor company, dissenting partners of the transferor LLP will be given a provision to exit out of the firm. Any other consequential matters? Up to here, everyone understood the point clearly? Okay. Next. Whenever tribunal sanctions it, see here. No compromise or amendment proposed for the purposes of or in connection with the scheme of amalgamation. That means any amalgamation with any other LLP shall be sanctioned by tribunal unless tribunal received a report from registrar. Means tribunal will give a sanction if it receives a report from the registrar. What report? It should receive a report that affairs of LLP, both the LLPs, has not been conducted in a manner prejudicial to the interest of the partners or public interest. Means if the affairs of the LLP, new LLP or old LLP is conducted against to the public interest, against to the interest of the partners, then sanction will not be given. Up to here, understood the point clearly? Next. That's all. Remaining is only just a procedural aspect. All the assets and liabilities will be transferred from transferor company to transferee company. No further execution of document is required. And within 30 days, you need to file the sanction order with ROC or else penalty will get attracted. Okay. The main concept I wanted to tell is these 5 will be tested in exam here. Next one, these 2 points will be tested in exam. Be extremely careful. Okay. That's all. The whole logic is very simple. Compromise or arrangement is of 2 types. One is a general compromise. Second one is a arrangement. Arrangement la amalgamations will come. Okay, application form what you use for section 60, same application form you will also use for section number 62. That's what I wanted to convey. Clear everyone? So this is the end of all the concepts inside this particular area called as LLP. Prepare well, write well in the exam. Regarding these 2 questions, compromise in 60 and 62, one question will come in exam. Pakka it will be asked. Okay, be careful, present it properly. Thank you.